possession charges it's a mere allegation that, hey, look, you were possessing this substance. I don't know that it says anything about whether this person is using addicted,
Right.
intoxicated, or dangerous. And so I think there's a big blind spot here.
I agree.
We are the Armed Attorneys. Today we're talking about a new trend we're seeing with FBI NICS denials.
Yeah.
This one is a little bit new. Not too many people are talking about it. If you're a member of the Armed Attorneys Insider Newsletter, you got a little sneak peek of this stuff. If you're not a member of that, you need to jump on there, armedattorneys.com. But we're talking about a lot of people getting denied for convictions that, stuff that was laying dormant for some period of time. But we're going to be talking about all this and more. But before we begin, show your support for the Second Amendment by hitting that like button. And Leslie, this kind of started with one of your guys. We consulted a lot of different lawyers.
We did,
and
which is rare.
Yeah, we'll bounce ideas off each other, but rarely do we all talk about something, go talk to people outside of the firm, and then, but this is a new thing.
Yeah, so we had someone call in and say that they were denied the right to purchase a firearm as a result of a conviction for less than 2 ounces of marijuana, which in the state of Texas is a Class B misdemeanor. So it's one step up from a traffic offense. Arguably the less egregious or the least egregious misdemeanor you can have aside from a traffic offense. There's some counties in the state of Texas who actually don't even prosecute these cases. They just don't even find it useful. And this conviction for such a small amount and possession of marijuana caused him to not be eligible to purchase a firearm and arguably potentially be considered a prohibited person for this time being. So went to try to purchase a firearm, has purchased firearms in the past, had no issues, no prior criminal history, no criminal history since then, no violent history, no felonious criminal history, nothing like that. So nothing else that would prevent him from possessing a firearm. And it was actually denied and received a letter from the ATF saying that because he had been convicted of a drug offense within the last year, that he was considered an addicted person and an unlawful user of drugs.
Yeah, and so it's a little bizarre because obviously we see all the states kind of loosening up on marijuana.
Yeah.
We've even seen the federal government loosen up a little bit. Now, we got a modification to the ATF Form 4473 not that long ago that, basically outlines, hey, look, marijuana is still illegal under federal law. So,
right.
They kind of tip their hand. That's the same time when they rearrange things so all the information's on one page, but whatever. Clearly, federal government still enforcing it. Now, what's strange about this is, okay, so we have the law. It's under 18 U.S.C. 922 D3. I'll just read this so everybody knows what the prohibition is.
Yeah.
Shall be unlawful for any person to sell or otherwise dispose of any firearm or ammunition to any person knowing or having reasonable cause to believe that such person, including a juvenile, is a unlawful user of or addicted to any controlled substance. So that's the D. That's about the transfer law. So, and then we'd find the corresponding provision under G3. It'd basically say can't possess it as an individual. So we're talking about our guy being denied his firearms purchase. That's the law that we're looking at. And we get our definition of what a unlawful user of or addicted to any controlled substance. If you wanted to check this out, it's in 27 CFR 478.11. This is the meaning of terms. Look up unlawful user or addicted to any controlled substance. And this is where the ATF has greatly expanded, the Congress said, hey, unlawful users prohibited. This is when they say, hey, this is what all these things are. And include in that list is, there's kind of this presumption that you're an unlawful user if you've been convicted of a drug offense within the previous year. And that has sat dormant. This is our experience. We've been doing this a long time.
Right.
That has been sitting dormant for a very long time and not enforced.
I have never had someone call me and tell me that they were denied the right to purchase a firearm for a misdemeanor possession of marijuana charge. And that's what I was telling this individual. Because he was very upset with his original attorney for allowing him to go forward and not explaining this. And, I was telling him that I've never seen someone denied for this reason. Richard and I went and talked to Edwin. Obviously, Edwin's been doing this longer than anyone else here. And he said he's never seen anyone denied for that. So obviously the ATF is ramping up and they are really looking into this and they are checking the databases. The other thing that I thought was interesting was that, in here, and also the letter that he received stated that if you have admitted to a police officer, same thing within the last year, of using any sort of narcotics.
Or a positive drug test.
Does it
seem like the FBI is going to be enforcing that? can't imagine. Hot UA test.
Right.
However that gets reported to whoever.
Right.
Now you're a prohibited person.
Right. Well, and I mean, the police officer, how are they reporting it? I mean, what stops a police officer from going and saying that, hey, yeah, Richard Hayes reported to me that he used marijuana 4 days ago? I mean, I don't know, that's kind of scary. And, we talk about being out on bond, and, typically a condition of bond is that you get drug tested. And, we both know judges who routinely drug test people who show up in court. So you show up to court, let's say that you actually, maybe had stopped using marijuana after you got arrested, but you still test positive that first test, and that gets reported. Is that preventing you from possessing a firearm?
Yeah, no, I mean, let's say it's not even a drug charge and you get randomly drug tested,
Right.
because that happens,
Right. Well, I will say, we have people who say, well, so if you've never been arrested before, what are the chances that these terms are imposed on you? They are. Every single one of my clients that I have had in the last 8 years of being a criminal defense attorney have had to have random drug tests. I mean, I'm comfortable saying that. I can't think of one who that wasn't one of the terms of their bond condition. Now, there might be some who actually never got drug tested, but I want to say almost every single one of them, a term of their bond was that they could get randomly drug tested.
Yeah, and so it got us thinking, what is the reasoning behind all of this?
Yeah.
Well, we have a Supreme Court case where the Supreme Court has granted a writ of certiorari from the United States government. We have a Fifth Circuit case. I'll read it here. It's United States v. Ali Khamenei. This is case number 2440137. And in this case, we had basically a guy got indicted for being an unlawful possession of a firearm, for being an alleged drug user. He moved to dismiss his indictment. The district court agreed with him, and there was this kind of agreement between the government, right, where they said, okay, but we're going to reserve our right to appeal. This is a rapidly developing area. Went to the Fifth Circuit. They affirmed it, saying, hey, look, as applied to him, you haven't shown this unlawful user. They kind of sidestepped this CFR definition a little bit, and they're more focused on, hey, what did the Congress actually write? But ultimately, they found that the provision as applied to him, unconstitutional, no historical analog, all this other stuff, government agreed to it. Well, now, and there's a lot more in-depth analysis out there regarding that case, and we'll cover it when it comes up, probably June 2026. We'll probably have some news on that front. But we see a trickle of cases, especially in the Fifth Circuit, that say there has to be some kind of link to dangerousness,
Right.
to intoxication, to a lot of different factors that would support this prohibition as a think of an unconstitutional infringement of the Second Amendment. Now, possession charges it's a mere allegation that, hey, look, you were possessing this substance. I don't know that it says anything about whether this person is using addicted,
Right.
intoxicated, or dangerous. And so I think there's a big blind spot here.
I agree. I mean, just because you were in possession of a narcotic does not mean that you use the narcotic. I've seen plenty of cases where someone has a kid who had drugs, left it in their car, and now the parent ends up getting charged because their kid had drugs in their car, and the parent never actually used it, but they were in possession because they were in care, custody, or control. I'm sure that there are a fair amount of people who possess narcotics and do use them. But again, this person was not convicted of using marijuana. It was possession of marijuana. There were no hot drug tests. There was no admission to use of marijuana. So, saying that someone is an addicted person simply because they were in possession of something, that's really, really crazy.
Well, and like what we've seen with other, think misdemeanor crimes of domestic violence.
I was just thinking that.
We have certain data that gets reported to the FBI, who is the party involved, what is their relationship to the other person, in this crime, was there an element of force or threatened force, because I will say with regard to that, maybe it's an unconstitutional infringement on the Second Amendment, don't get me wrong, setting that aside just for a moment, but the federal government is having a basis, or at least they have an argument for this, because the Congress wrote a law, they've collected that information, the two things square each other. I don't know that any of this information is being collected, transmitted to the FBI, and they're just kind of making a lot of assumptions.
Yeah. With the misdemeanor crime of domestic violence, there's people who were, pled to Class C assaults that and again, years ago pled to these that had no repercussions, and then retroactively now they're getting denied a license to carry based off that. But I mean, I think this is very bold. This is going to affect a whole lot of people.
Yeah, and this isn't any commentary on like legalization of marijuana or whatever.
No.
This is just a, hey,
Yeah.
is this an unconstitutional infringement of the Second Amendment? Well, in the Hermani case, yeah,
Yeah.
clearly. And in our recent client's case, yeah, also in that case. So
Right.
if we're going to have a lot of different cases where these are unconstitutional infringements, it's going to take a lot of legwork for the government to apply this challenge to a lot of different circumstances to figure out what the criteria are. I mean, we're setting ourselves up for a real nightmare.
I agree.
Yeah.
I agree. And, it's a lot to keep track of. It's a lot to keep up with. And, the pace at which things are changing and coming out, I mean, it's very scary.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to question in the comment section down below. Join us over at armedattorneys.com, join the Insider newsletter, and until next time, we're the Armed Attorneys.